Any questions about the doctrine of selective incorporation? It is not the doctrine of total incorporation. Why is it not the doctrine of total incorporation? Well, because the Supreme Court has never said that everything in the Bill of Rights is protected against the authority of the states through the 14th Amendment due process clause. It's done it on a case-by-case, provision-by-provision basis. That's what the doctrine of selective incorporation means. Now, I understand this is not a law school course, but this is such an important component of our law, and particularly as it pertains to the criminal justice system, that I just don't think that we can gloss over it or ignore it. Certainly, we have to understand why the federal courts, and particularly the United States Supreme Court, have played such an important role in the criminal justice system as it applies to Texas or any other state. And the 14th Amendment is a big part of that. Okay, there's one other issue I want to touch on before we get to the details of the criminal justice provisions, okay? It's a general issue here, okay? With any of these civil liberties rights that we might talk about, whether it's the right of free speech or the right of free worship or the right to counsel or the right to keep and bear arms, or whatever the issue is, it's always a matter of line drawing. None of these civil liberties rights have ever been recognized by the courts, the United States Supreme Court in particular, as being absolute. The right of free speech is not an absolute right. You can't say anything you want, anytime you want, under any circumstances you want. The right of free worship is not absolute. You can't do anything you want in the name of your religion, even if it violates federal or state or local law, and claim that you can't touch me because I have a right of free worship. Yes, sir.
And like I'm just watching from like the back and like watching like everything play out in the way like how everything's going today. But there's one thing that I will say like that I saw recently that I like have watched to make sure it's factual. So our president did say that no amendment is absolute.
Yeah, I had a conversation about this with one of your classmates after Tuesday's class meeting. And I told your classmate that I had not heard President Biden make that remark. I hadn't read anything about it, but I had been pretty immersed in other things, okay? And I still haven't, I'm still immersed in other things, and I haven't really gone out to read any news accounts. But I'll share with you what I shared with your classmate, okay? Bearing in mind that I am willing to admit that I could be wrong about this, okay? But I suspect that the president, Mr. Biden, misspoke. What he really meant to say was that none of the civil liberties rights in those amendments that are embodied in those amendments have ever been considered to be absolute. Okay? Now, obviously, Mr. Biden's critics, Mr. Biden's opponents are going to jump on that, right? And maybe that's fair, right? Maybe the president should be more careful about his word choice, right? I do know, and again, I shared this with your classmate, that I have some sympathy for Mr. Biden. I don't necessarily consider myself a Biden supporter, but I have some sympathy with him as a human being because I'm not sure if you're aware of this. He has struggled with a lifelong stuttering problem.
Yeah.
I've known people very close to me in my life who have struggled into their adulthood with stuttering, and it can be a real challenge to divert your mental energies when you're trying to not stutter to necessarily pick the right word in a particular circumstance. And I think that there's a chance that that's what happened to Mr. Biden. He may just be misinformed, right? Maybe he got that line from an aide, right? And he didn't think about it very carefully, or they didn't analyze it very carefully. But what I think is more likely is that he just misspoke and what he meant to say was that the right of free speech has never been considered an absolute right. The right to peaceably assemble has never been considered an absolute right. The right to keep and bear arms, which is, I think, what motivated the comment, I think he was probably trying to say, should not be treated any differently than the right of free speech. It's not somehow sacrosanct, and that we should treat it somehow as an absolute right, where the government, or more generally that we as a civilized society, don't have some interest in imposing reasonable restrictions on the exercise of that right. We can, as a civilized society, impose reasonable restrictions on people's exercise of their religious faith. Yeah. The First Amendment says that Congress shall make no law prohibiting the free exercise of religion, but that doesn't mean you can do anything you want in the name of your religion. Yeah. I mean, the obvious example, you can't practice human sacrifice. Yeah. And then when the police come and arrest you for murder, say, oh, I have a right under the First Amendment to freely exercise my religious faith. You can make that argument all day long as much as you want, but you're not going to prevail, I'm pretty confident. Right? By the same token, as I always like to say, you can't drive through a residential neighborhood at 3 a.m., blaring some message over a public address system, waking up all the neighbors and whipping the dogs into a frenzy, and when the police blaring some message, and when the police come and arrest you for disturbing the peace, say, hold on a second, I've got a right under the First Amendment of free speech. Again, you can make that argument all day long, but we have always recognized as a civilized society that you can that the government can impose at a minimum time, manner, and place restrictions on the right of free speech. And not only time, manner, and place restrictions, but there are certain types of speech that aren't protected. We know, I hinted out a few minutes ago, obscenity is not protected speech. You can't use obscene speech and expect not to be prosecuted. You can't libel someone. You can't slander someone and use the First Amendment as protection. Fighting words are not protected speech. How do we know this? Well, because the courts have told us that fighting words are not protected. Libel, you can't libel, so you can't defame someone and damage their reputation and all that goes with that and claim the protection of the First Amendment. So if the First Amendment right of free speech is not absolute, and that as a society we can impose reasonable restrictions on that, I suspect that the president was wondering out loud, or asserting, I guess is a better choice of words, asserting that it is also possible then for the government to impose reasonable restrictions on the right to keep and bear arms. Again, I could be wrong. I could have that entirely wrong, but I suspect that's what motivated the whole episode.
I was just asking, just because we were talking about it.
Yeah. I understand. Yeah. I think he uttered the word amendment, but he would have been better advised to utter the words civil liberties rights.
Yeah, look at the video for me, and then.
Okay. Yeah, when I can get around to it, I plan on looking at it, because as I said, I've already had this conversation with the classmate. Okay, so that particular point about Biden aside, the broader point that I'm trying to make here is that it's always a matter of line drawing, whether we're talking about the right of free speech or the right of free worship or any of these other civil liberties rights, where you have, on the one hand, the right of the individual, perceived right of the individual, right? And then on the other hand, you have the state, and I'm using that term state here very broadly just to mean the authoritative nature, the authoritative aspect of society, the ability of society to authoritatively make rules and regulations. So it can be the national government, it can be the state government, it can be the local government, right? Or the community, right? Does the community have a compelling interest here? Okay? And then it is a matter of determining where the line should be drawn between the right of the individual on the one hand and the interest that the community is asserting on the other hand. Because when the community passes a law regulating speech or regulating gun possession or regulating public demonstrations or whatever the case is, it is invariably going to be asserting some interest. The reason that we're doing this is because we're trying to prevent some substantive evil, right? Does the community have an interest in promoting stable civil society, for lack of a more general way to put it? Yeah, of course. Is that interest that the community has in that common objective compelling enough to warrant intrusion into the individual's right? That's the question, the practical question that the courts then end up taking up as a matter of line drawing. I've drawn this line as a broken line because I'm trying to suggest to you that it is not clear. It is not clear in any of these areas. It's not clear in any of these areas for all time where the line is to be drawn. Okay? So we really just kind of have to take it on a case-by-case basis. But what we can say is that in most scenarios, in most of the cases that arise, it is the burden of the government, whether it's the national government or the state government or the local government, to establish why its interest is compelling enough to warrant the restriction of the individual's civil liberty right. What is at stake here? What is so important? What is so important to the community here that justifies curbing the individual's right of free speech or the individual's right to keep and bear arms or whatever the specific civil liberties right is that we're talking about?
It could be like the rights of the other citizens. If they're being affected by this person using their right to negatively affect their rights.
Yeah, I mean, I think that's one very general approach that the government is going to try to take, that the individual's right to enjoy his right of free speech or whatever the specific right is only goes so far as it doesn't infringe on other people's rights. Okay, so that's a very general consideration. But oftentimes when we take up when the courts take up these specific cases, they are looking to the specifics. They're not looking to that general. They're looking to say, in this specific instance, this law that the local government has passed or the state has passed, which clearly restricts free speech rights or clearly restricts gun ownership rights, is the interest that it's asserting compelling enough to warrant or justify that restriction of individual liberty rights. And the reason, by the way, just to go one last time to the gun rights thing, the reason that we have less certainty in the area of the Second Amendment than we do, for example, in the area of the First Amendment, some of the other civil liberties rights, is because it's so new. Okay? It's taken decades to work out where the line is drawn in the right of free speech and some of these other areas. It's been 10 years since the court handed down that decision in that Illinois case. So I suspect that in the years to come, in the decades to come, as California or New York or Massachusetts or whatever other state passes laws trying to restrict access to firearms, and those get challenged in court, and some of them make their way up to the United States Supreme Court, it's going to just take some time for the court to work out all those details. There's very rarely in any of these areas sort of a overarching decision of the court where we can just say, in every instance, this is how the law is going to apply. I can't think of any example in any of these civil liberties areas. Okay? So we've got two things sort of of general nature that you got to keep in mind as we work through these criminal justice issues. The first is that the Bill of Rights has been selectively incorporated, and that includes the specific amendments that we're talking about, the 4th, 5th, 6th, and 8th Amendments. Okay? even though in my examples here, we focused on the First Amendment and the Second Amendment, those aren't as relevant to criminal justice as we need to get into, right? So that's the first thing, this doctrine of selective incorporation, and certainly for no other reason for the purposes of a quiz, you need to know what the doctrine of selective incorporation is about. And then the second matter is this matter of line drawing, right? It's always a matter of line drawing in an attempt on the part of the courts in saying what the right of free speech or the right of free worship or the right to keep and bear arms or whatever the specific right is, in saying what it means or what that provision of the Constitution protects. It is a matter of trying to balance the interests of the community against the rights of the individual, determining where that line is drawn.